Trading with the Enemy Act, Constitutional Implications and Historical Analysis. 1. Origins and Purpose of the Trading with the Enemy Act, 1917. The Trading with the Enemy Act, TWEA, was enacted by Congress on October 6, 1917, during World War I, under the administration of President Woodrow Wilson. Its primary objective was to prevent any form of commercial engagement between American individuals or entities and foreign nationals or governments classified as enemies of the United States or allied with such enemies. The statute, codified as Public Law 65-91, 40 Stat. L. 411, was designed to protect national interests during wartime. Section 2C of the Act explicitly defined enemy as nationals of countries at war with the United States, while deliberately excluding American citizens from such classification. Section 5B similarly ensured that the regulatory powers conferred upon the President did not extend to transactions among American citizens within the United States. 2. Post-war status and the 1933 expansion of presidential authority. Although World War I concluded in 1918, and most war powers were repealed in 1921, the TWEA was granted an exemption from the general termination. This dormant statute would later become the foundation of unprecedented executive action. Following the financial collapse of 1929 and the onset of the Great Depression, Franklin D. Roosevelt, upon taking office in 1933, invoked the TWEA to justify broad emergency powers. In his inaugural address, Roosevelt compared the economic crisis to a military invasion, signaling his intent to leverage wartime authority in peacetime. On March 6, 1933, citing Section 5B, Roosevelt issued Proclamation 2039 to close all banks nationwide for 5 days. While the original act was designed for wartime application, Roosevelt's maneuver reframed financial instability as a national emergency, thus broadening the scope of presidential authority. 3. Expansion of Section 5B and permanent emergency governance. The language of Section 5B was subsequently amended to authorize the President, during wartime or any declared national emergency, to investigate, regulate, or prohibit foreign exchange transactions, control transfers of credit between banking institutions, oversee the export, hoarding, or melting of precious metals, compel individuals or institutions to produce records and submit sworn statements. These powers apply to any person within the United States or subject to the jurisdiction thereof. This phrasing effectively subjects all domestic persons to regulatory authority previously reserved for enemies of the state. On March 9, 1933, Roosevelt issued Proclamation 2040, reaffirming the national emergency and the continued applicability of Proclamation 2039. Importantly, no end date was specified. As no subsequent president has rescinded the declaration, the emergency remains in effect to this day. 4. Legal and constitutional consequences. The persistence of TWEA authority, despite the cessation of hostilities, has resulted in an enduring state of emergency governance. Under its terms, the President holds sweeping authority to control domestic economic activity under the guise of regulating enemy transactions. This framework, though initially conceived for wartime national defense, now allows the President to designate any person, transaction, or resource as subject to regulation. The absence of judicial oversight or congressional expiration dates enables unilateral executive control over core economic and civil liberties. 5. Congressional Oversight and Senate Report 93-549. Senate Report 93-549, issued in 1973, provides a comprehensive review of emergency powers in the United States. The report acknowledges, a majority of the people of the United States have lived all their lives under emergency rule. For almost 40 years, freedoms and governmental procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. This finding underscores the constitutional significance of the TWEA. What began as a measure to restrict foreign economic threats during wartime evolved into a permanent fixture of executive power, fundamentally altering the relationship between citizens and the federal government. The Trading with the Enemy Act thus serves as a cautionary case study of legislative overreach, executive opportunism, and the fragility of constitutional protections under conditions of declared emergency.